Welcome everyone. I am absolutely delighted to invite you to this last piece of our PhD seminar here at Middlesex London, and truly delighted to have such a fabulous, wonderful authority and wonderful person to have with us, Professor Louis Sargentich from Harvard Law School. So hello, Professor Sargentich. Hello again. We are
hello.
Here. Hi. So
okay,
good.
should I begin, Damjan?
Yeah, so basically, I mean, I guess Professor Sargentich does not need much of an introduction. Let me just say that he was teaching, he still is teaching jurisprudence. He was teaching torts at Harvard Law School. He's been teaching at Harvard for about, I think, over 40 years, if I'm not mistaken. He was also clerking for the US Supreme Court. I mean, just I won't go into all the details so that we can start, but really a fabulous, fabulous legal scholar. He also taught the methodology seminar for doctoral students at Harvard Law School. So I was participating in that seminar and learned so much legal theory from him. So really welcome, warmly welcome, Professor Sargentich. We're so happy to have you here. Before we start, I would just like to briefly introduce Professor William Schabas and Julia Pecorella, who are basically leading the PhD program here at Middlesex as well. And so
good afternoon. Thank you for coming, Professor.
Hi, Julia.
Hi.
Very nice to meet you.
So
okay, good. I see on the screen. Thank you.
Great. So let me just say that we have a mixed crowd here. So mostly PhD students, some students from some master students, some colleagues. So it's a very mixed audience from people from all around the world, I have to tell you. So, you know, we are a global university. We also have, not just because we have a campus in Mauritius and Dubai as well, but we have students from everywhere. And we are truly, truly delighted to have you here. So thank you so much. Professor Sargentich will speak for about 30 minutes, 45 minutes, and then I'll open the floor for discussion. Thank you for sharing your thoughts and really telling us about this fabulous book.
Well, so thank you for the very, very kind introduction. Hello, everybody. I'm happy to be with you. And actually, first, it's a great pleasure to be together with your professor, Damjan Kukovec, again, and meeting here in the ether. And we interacted a lot at my law school some time back. So it's a pleasure to be re-meeting, reacquainted, and in the same session. And then I have to say, it's it occurs to me that this is the first time that I've been inside, this is metaphorical, a classroom in a British university since I got my degree at the University of Sussex over 50 years ago, 1967. And so anyway, that's a nice aspect of today's session for me. So thank you very much, Damjan, for the I could listen in a little bit. We had to do other things here, but a little bit of summary of the ideas of the book that's really helpful, because I tell you, it's a challenge to take a book that you've written and you struggled with all the pages and all the ideas and to boil it down. And that's what I've been working to do. And I'll certainly have a shot at that today. But anyways, a little bit of an intro was awfully helpful to that. So what I have in mind is addressing in my initial part of today's session the general ideas of the book, and a little bit kind of on the strategy of the book and the pattern of argument that it presents. And so here's a real short version, and then I'll go back over this stuff. The short version goes like this. We engage in doing law in a practice of legal argument, where we present arguments based on laws to come to judgments. And that kind of legal argument is conducted in courts by judges and lawyers to judges, and in social life by people who are prepared to make claims that could be defended in court. And in our kind of legal practice, there is a general aspiration or commitment to try to make arguments based on law such a way, and come to judgment in such a way that the, in a phrase, rule of law is maintained, is sustained by the processes of argument and judgment in the courts of society. So then the book says, well, what happens when you have a practice of legal argument? There are lots of practices of legal argument in human history, and they certainly don't all have this particular conception of the rule of law as their aspiration, but ours does. And so what happens when you plug that aspiration into a practice of argument centered on the courts? And the book makes the claim that, well, what happens is that certain characteristic argument forms arise. In fact, two basic forms, two different pursuits arise, and then a third kind of pervasive aspiration or undertaking arises. The two pursuits are to hammer out the law's rules, the formal rules, and number one, and number two is to attribute principles, policies, and purposes that make sense of, guide, and shape the rules. And the pervasive quest is for coherence, to make these things fit together, fundamentally in order to achieve legal justice. So that's the claim of the book in general. And it goes on to say, well, how do we look at it? What's a good picture of the pursuits that arise? Hammering out the law's formal rules, attributing ideal propositions, practical moral aims to rules. What's a good picture of either one? And at this point in my remarks, I will mention three actually proper names, but that's it in my remarks. There are H.L.A. Hart, they're pretty well-known people. H.L.A. Hart and Max Weber as giving a portrait of law's formal rules, and Ronald Dworkin is giving a portrait of principal policy type argument. And that's it, so far as name dropping by me is concerned. But I want to talk about the portraits of our law, not the same, but with some interesting parallels that I regard as good portraits of what legal argument is trying to build. And then towards the end, or maybe through questions, we'll see. I keep my eye on the clock here. I don't want to talk myself too long without conversation. But anyway, and then I want to eventually make the point that these authors, whom I regard very highly, fall down, each one of them, in the picture that the author has of the other form of argument. Somebody affirms rules, good picture. Somebody, that same person, criticizes principles, policies, bad picture. That's what I'm going to claim. And in reverse. So anyway, the critical edge comes towards the end of my talk. Okay, so now take it from the top. That's what I'm going to try to do. The idea of law as argument. I wanted to start with that. That's an idea that has a history, and we can actually identify it in certainly in American legal culture at a particular time, and it's the 1930s. and the school that emphasizes law as argument is called legal realism. And this is a school that strongly influenced H.L.A. Hart, by the way, as you see in his writing. But the idea of legal realism that I'm getting at now is that when you ask the question, what is law? And it's been asked for a long time. The best way to approach it is actually change the question a little bit and say, how does law work when it's in motion as grounds of judgment? So how does law appear? How does it unfold when it's used as reasons for criticizing conduct or justifying conduct legally? Anyway, that's what I mean by law as argument. And legal realists said this is the way to look at law and find out what happens. Second idea here is that I think we should, and the book says this, imagine legal argument, but happening within a practice. So it's just this idea of practice of argument. That's the second general idea. So what's a practice of argument? It's a discourse. It's argumentation, which is instituted in social life, an instituted discourse, meaning that it's an argument. Well, the easiest way to see it is practice of legal argument is argumentation going on by judges in courts as they come to judgment. And then it's argument to these same judges looking to present arguments that the judges could embrace. And then it's any other argument anywhere in the society that has in mind presentations that could be made in court to judges or by judges. That's a lot of argumentation, and all of that's a practice, a unified kind of talk, unified by criteria of what's a good legal argument, what's a good and sufficient legal argument. So the book talks about this and talks about the notion of a practice of argumentation that's controlled by shared canons of good argument. This is a general idea, by the way. I mean, we can talk about a practice of scientific argument too, be a different one, obviously. But the claim is that that legal argument is, as I think Professor Kukovec was saying, is not just kind of a free-floating thing, or like moral argument is not just in law. In law, it's not just a free-floating thing. It's shaped by criteria. And the criteria that are used, the book argues, to define a good and sufficient legal argument include, crucially, an aspiration that's particular to our kind of law. The name of the book is Liberal Legality, so it's trying to point at a particular kind of legality that actually is pretty widespread in the world today, but by no means universal, and surely not in human history. Anyway, the idea is this: take a practice of argument, has its criteria of good and sufficient legal argument, plug into it a particular aspiration. That's the aspiration to achieve the rule of law. Now, the book says, I argue in the book, that this aspiration to achieve the rule of law can be captured by three terms: entitlement, justice, and rationality. That's the trio. So if you're shooting to make judgments under law, you want to sustain people's legal entitlements, where the standing law is the ground of something valued, a valued position of some person in social life. You have a legal entitlement when you can stand on the law and sustain a valued position. And legal entitlement exists when, through reason, we can grasp what the grounds are and set them in motion to a result. So the rule of law says legal entitlement should exist. There should be a government of laws, not men. That's an American slogan, John Adams, one of the founders, American Constitution. Here's a much older one, not under men, but under God and the laws. Non sed homine sed sub Deo et lege. Very familiar. So under law, entitlement, legal justice is the idea of deciding like cases alike, of having decision be made under general standing laws whose categories are general and are generally applicable, so that the resolution of your case under the laws is aligned with other cases. There's a pattern when legality exists, when the rule of law exists. And that, of course, is a very familiar notion, the idea of like cases being decided alike, but it is part of a particular aspiration for law, the liberal one that I'm describing. In the American, in the US, the Supreme Court building in Washington has the phrase chiseled on the pediment of the building, equal justice under law. Well, that's this idea of legal justice. And legal justice says that you have a right, you have an entitlement to justice in a law-governed society, a right to resolution under the standing law. Right to justice, or the quest of justice, means that there's a push, a strong push within the legal system to line up the various grounds of the law. Because we can sort of say, well, maybe it looks like legal justice if there's some general rule that applies to your case, because you fall within that rule. But if there's a counter rule, another rule in the legal system that goes the other way, if the rules don't jibe with one another, then legal justice is actually offended. So the aspiration to achieve legal justice is a biggie. It's the aspiration to see a pattern for all the cases, ultimately, that they all can be lined up according to general propositions of the law, which define the distinctions and variations in treatment of people who come to judgment. So anyway, the push to legal entitlement is a deep, deep, deep idea of standing laws that govern results. Push to legal justice is a deep, deep, deep idea of the consistency and coherence of the propositions of a legal system, and therefore all the judgments delivered by a legal system. That's the aspiration. The book uses a term, nomological, that I think is a good one. Etymologically, that just basically, nomos is law. It means law-like. And so I'm describing the aspiration to achieve law-like legality. And law-like here means under law, entitlement, and consistent, coherent, according to law, justice. And both of those parts of liberal aspiration, entitlement and justice, presume rationality, that is to say, the operation of reason, in common reason, in human reason, in grasping the meanings of the laws, the fact that laws exist and what they mean, and reason in the operation of the laws, and going from grounds to result, and in squaring the results with one another. That's nomological rationality, law-like rationality that is involved. Law-like rationality requires law governing in a rational way judgment, particularly judgment, and in order to get there, it's rational connection of all of the laws, an aspect of legal justice. Okay, so here's this aspiration of legal entitlement, justice, and rationality. And the book asks a question, what happens if you set up such a practice and it starts operating? And what happens is, the question is, it's a practice of argument centered on the courts, but with lawyers and people in social life looking at it and participating, which is governed by this rule of law devotion. So what kinds of argument arise? What's legal argument like? Anyway, the book makes the claim that, well, what happens is that two kinds of argument arise in law. Two different types of pursuit arise. And suffusing those two types, a general quest. And so the book calls this a threefold quest. The two types of argument, and here I drop a couple of names, are the project of hammering out the laws as rules, as formal rules, knowable formally, come back to that. That's one pursuit, formalization of the law. And then the other pursuit is attributing principles, policies to the rules, using them to guide and shape the law, and that's called idealization of the law in the book. So the two projects are formalization and idealization. We'll come to the third thing in a minute. And the name dropping that I think works pretty readily is to say that, well, a picture of formal law, formalization of law that's pretty familiar in reading legal theory is that of H.L.A. Hart. And his picture of how legal argument goes in his book, The Concept of Law, and in his many articles. So according to Hart, law in motion is argument, is rules. These are legal grounds. A rule is a prescription, which is knowable without the conduct of a moral inquiry. So it's formal, it's non-moral. It's knowable when you find that it exists as law, and Hart has interesting stuff about that. But in any event, it's legal argument for Hart is a matter of rule-based argumentation, and that's a formal pursuit. Hart's sophisticated about rules. He knows that they open up at a certain point. But what I'm getting at is, but that's a marginal thing, the degree that they have a penumbra and they're open. But for the most part, law, knowable law that we have in society is, in fact, working to carry out the rule of law. That's rules. That's picture number one. Picture number two, again, a familiar name, I think, is Ronald Dworkin. Dworkin says, oh yeah, rules are important, but they're very open-ended and they need guidance. They always need guidance. And the guidance comes from laws, principles, and policies. And so that's what I'm calling ideals, legal ideals of principles and policies. They're practical moral aims, which Dworkin says are rooted in the law because these principles and policies fit the rules and justify the rules, and they have a legal status. So they're part of legal argument just as much as the rules are. But they're the crucial part because it's when law turns to principles and policies that it gets its shape and its constraining power, constraining the mind to judgment. So, claim I'm making, I'm agreeing with this in the book so far, is, yeah, it's true. Take a practice of legal argument, collective operation of discourse, governed by some criteria of good argument, plug into it the aspiration to the rule of law. What you get is, and this is the term used earlier, a dual impulse, two pushes, a push to formalize the law, hammer out the law's rules, a push to idealize the law, attribute principles and policies to the rules. That's a general claim. of the book. There's a fundamental duality in our kind of legal argument. But the third thing is a threefold quest that arises. The third thing is coherence seeking. And the claim is that is, if there's one signature of our law, what I'm calling liberal law, it would be that. It'd be the quest of coherence. It comes from the quest of legal judgment, of justice. The quest to make the laws consistent and to work together and to have a consistent, Dworkin has a lovely phrase, articulate consistency. That's coherence. That's where you make things consistent. Yeah, you have to have that, or you don't have like cases decided alike, almost, by definition. Coherence is consistency that's articulate. You can state the way in which the laws are consistent. Anyway, that's, to me, coherence just is articulate consistency. But there's a push to that, according to the book, in both of the branches of argument. There's a push to make the formal, when you engage in formalization of law and you hammer out the law's rules, there's a push to build structures of rules, doctrines that coordinate rule elements, rules and counter rules, qualifications, and the like. There's a push to build formal structure, and there's a push to build ideal structures, principles, and policies for the same reason. So two pursuits arise and a common form of the pursuits, coherence seeking in each. Now, the book says that when you look at jurisprudence, writing that tries to describe law's logic, there are two figures that stand out as providing really good pictures of coherence seeking formal argument, number one, and coherence seeking ideal argument, principle policy argument, number two. There are two pictures that we can point to by very well-known writers, which are good in describing the projects of liberal law. Now, the first one I'm going to say has a good picture is Max Weber. He's actually a legal sociologist. We'll come back to that. And the second good picture I already mentioned is Ronald Dworkin. H.L.A. Hart, I think, is a very helpful writer, but he really doesn't have a good picture of law's coherence seeking. He certainly takes it for granted, but he doesn't have a great picture of it. But Weber does. So I'll just do Weber and Dworkin here. Max Weber is the great sociologist, a general sociologist, known for so many different propositions. And actually the one question we sort of have pending about the jury, Weber is wonderful on discussing the jury. But he's a German sociologist. He wrote actually thinking of the great intellectual product, the German Civil Code, which came down, was established down the pike, I started to say, in the 1890s. Max Weber died in 1920. And so he's often reflecting on the German Civil Code, which is this wonderfully integrated picture of formal law. And so Weber says there's this push to formalize the law, achieve formal justice. And to do so, there are certain forces that operate in legal understanding. And these are forces of integration, essentially. Coherence seeking, in my terms. And so Weber has this wonderful picture of the development of legal argument, formal justice, as having a horizontal and a vertical kind of aspect to it. horizontally bringing together rules and counter rules, rules and qualifications, bringing together related doctrines, as we would say. His term integration, he has several terms, but that's one. Operates constantly in formal law, he says. And then the vertical one is that there's a push to generalize from more detailed rules and rulings of a formal kind to have, this is Weber, abstract propositions of high logical sublimation, generalities that can show the unity, articulate consistency, show the unity of a formal area of law, a formal doctrine. And that's what the authors of the General Civil Code were trying to do in writing out the laws for different parts of different aspects of civil law. That, to my mind, is, and the book argues, is a good picture of the kind of structure that is built in a legal practice that is shooting for the rule of law. And in our legal practice, and every lawyer knows that when you study some field of law, you study doctrines. These doctrines have parts, and they put things together. You don't study isolated rules randomly. Okay, anyway, so there's one good picture. And then the other good picture, the book says, is the picture of ideal argument, principal policy type argument, practical moral argument in law, offered by Ronald Dworkin. And Dworkin, once again, is not at all content with saying, hey, principles and policies are important, and they kind of come by one. Here's a policy, it worked hard in this case. Here's a principle, it worked in that case. The central claim in Dworkin's legal philosophy is that there's a push to make things jive, to connect things together, to fit things together, similar to the push that Weber identifies in formalization of law. But here at the ideal level, to build what Dworkin calls theories. A theory is a coordinated body of propositions, a theory of tort law, a theory of the constitutional law, or a theory of some area of tort law, like products liability for defective product, injury by defective product. A push to make things cohere in area after area of law. But for Dworkin, the important coherence is principles and general policies. In fact, they're the grounds of coherence of law, ideal propositions. So anyway, this image of, for Dworkin, you may be familiar with the idea that he has an exemplary judge, and this exemplary judge he calls Hercules, from the Greek myth as a hero, Hercules the hero. Hercules in myth does big tasks. Well, that's Dworkin's idea, that to do legal argument, maybe you're really focusing on a particular question, but back of that question is an understanding of how the law is aligned with itself. That's like Hercules ordering, neatening up the Aegean stables, bringing things together. So anyway, the push to coherence is dramatized by Weber's picture of formal realization of law, and likewise by Dworkin. Okay, so a lot of the book is saying just that. This push exists. And I guess you'd say that so far what I've said is pretty ecumenical. The book's drawing things together, and but it has a critical edge, this claim I'm making about liberal legality pushing to coherence in two veins of legal argument. It has a cutting edge. And the one that's that I want to, I guess, close with here is this. The book itself says, it doesn't actually develop an account of critical legal studies in the book itself. but it says how to do legal criticism. And it's kind of a pathway toward critical legal studies. The end of the book speaks of unanswered questions. So it points beyond itself. But within the book, there is a discussion of critique that's going on by Weber, by Dworkin. And the book says the critique that they're engaged in is bad critique. So there's an implied, or actually a stated, test for good critique, good legal criticism, good critical legal studies. And here's how that part goes. Book says Max Weber has a very good picture of law as formal rules and rule structures, but he has a bad picture of principal policy argument in law, a bad picture of ideal argument in law, practical moral argument in law. And the same thing for Dworkin in reverse. Weber says, okay, there's formal argument, and then there's something called substantive argument. There's substantive justice, substantive rationality. And that's practical moral argument. And so there are types of legality that put that to the fore, says Weber, not the formal kind, but the substantive kind. I'll just say the ideal kind, practical moral kind. But Weber looks at that substantive argument and says, the thing is, it's very open. It doesn't come to rational resolution in the way that formal law does. And you don't see regularity and system. Okay, fine, that's a critique. But his picture of substantive argument in law has more or less zero coherence in it. It's like substantive justice shooting for results with completely disaggregated, uncoordinated propositions. Nothing resembling Herculean theories, Dworkin type theories being built in the kind of law that Weber would assign to non-formal argument. So it's open but uncoordinated ideals, propositions, principles, and policies. And I want to finish soon here, but the book makes the same argument against Dworkin. Dworkin shows how coherent seeking works for principles, policies in law. He has a view of formal law, and it's an impoverished view of formality, rules. Dworkin says rules are open, so they need guidance by ideal theories. Fine, that's fine. That's the part of a critique of formality. But then Dworkin's picture of formal rules is really crude. It's practically nothing so far as the structures that Weber identifies are concerned. Dworkin sees formal rules as disaggregated and uncoordinated, kind of coming down the pike one by one. And the book says, the whole book is claiming that's a very bad picture of rules. So here you basically have, in two very good legal theorists, a good picture for Weber of the type of argument he wants to affirm, and then a bad picture of the type of argument he thinks is open, irresolute, indecisive. And the same thing with Dworkin, a very good picture of the kind of argument he wants to affirm, principal policy argument, and a bad picture of rule-based argument, which he says is open. Now, my quarrel here isn't with the claim of openness. It's with the misportrait of the other kind of argument by these authors. And the fact is, I'll just end with this, according to the book, the fact is that any openness you find in law should be openness in coherence seeking. Stick to that idea, because coherence seeking goes on. If you posit a form of law, like the way Dworkin looks at rules, where there's practically no coherence seeking at all, that's a sitting duck. How hard is it to criticize that? Not hard at all. So bad criticism, let's put it this way, bad criticism of law has a caricature of the law that you're criticizing as not seeking and building coherence at all. Openness without coherence. Good criticism of law says, sure, there's a quest of coherence, but it's open. So essentially what happens is coherence and counter-coherence are built. Structure and counterstructure are built. Theory and counter-theory arise or are present to choice. And so anyway, that's so far everything, just almost everything that I said is in the book, but it does point beyond itself to basically a definition of critical legal studies, which is to try and do good criticism and of both forms of law. And the criterion offered in the book is good criticism fully of our kind of law, our kind of legal argument, fully accepts that coherence seeking is undertaken and is real. Coherences, plural, are built. The thing is, and this is the critique, there's room for coherence and countercoherence. And that is the claim of critical legal studies. And so right at that very last bit there, I'm going beyond the book, but this is where it, I think, points. Okay, I've hit my marks here, as an actor might say, and that was 45 minutes. And
yes, thank you so much.
So,
Thank you so much, Professor Sargentich. This is so rich. And I have to tell you, I have so many questions for you. So I will start by asking some questions. And then I'll
super.
give the floor to everyone. So I will start and I will save some of my questions for later. So, you know, coherence seeking, this is really a big, such an important part of the book. And I will get to critical legal studies later on. Just like to clarify a couple of points for the sake of our students as well. So I remember when you were teaching us in your methodology seminar, and you discussed the issue that I think many lawyers, particularly from the continental tradition, are taught, that there is this distinction between positivism and natural law. And then you say there was a convergence basically in realism, right? American legal realism said, well, it's all about experience, it's about legal practice. It's not a dilemma between let's say formal law and ideal law. It is about something else. And I see this in your book as well. Please let me know if I'm interpreting this correctly. So this is just one point I wanted to raise also for the clarity of background of our students. And then I wanted to ask you, so you speak about, you say that this is a logic, this is a project of rational reconstruction.
Yes.
Obviously it is a post-realist reconstruction, right? So you're basing yourself on the idea that law is not about logic, law is not about mathematics, but still it is a rational reconstruction. So if you could possibly explain that to our students. And then the third question for the beginning of our discussion that I have is, you don't, when you speak about formal law and non-formal law, you don't say, I mean, you discuss it in great depth, but let's say, would you agree that when you speak about formal law, you also are thinking about the deduction, let's say, about you know, the legal method of deduction. And when you speak about ideal law, you're speaking about purposive reasoning and balancing. So these are just some questions that I wanted to clarify in the beginning for the sake of our students' understanding, and then I'll move on.
Okay, super, super. So tell you what, let me address the last one, and then can you cue me on one of the other ones? Because I'm having a little bit of trouble remembering everything all at once here. But
Sure.
I want to start with the last one. I like that a lot. Logic and balancing, say. Well, formal law, the simple picture of rule application is a kind of logic, and real simple logic, where you have a major premise, minor premise, conclusion. I mean, the syllogism. It's no vehicles in the park. This is a vehicle. This conveyance shouldn't come to the park. The middle premise is the classifying a state of affairs in terms of the norm, no vehicles in the park. HLA Hart's persistent example of a rule. So yes, that's kind of, that's logic, simple, subsumptive, syllogistic logic. The book basically says and assumes that that kind of move is at the tail end of a good formal argument. But before you get there, you have to sort out rules and counter rules, rules and qualifications, and figure out what the decisive rule is going to be. Then once you know it's no vehicles in the park, that's decisive, then you can do that last bit of movement. No vehicles in the park, but the police car can pursue a felon in the park, right? Rule, counter rule. But the fire truck can come into the park. But the device for trimming trees, it's a vehicle, can come into the park. You always have rules and counter rules. To get it down to one of them that can operate like a little syllogism requires formal reasoning of a larger kind. And that's where, okay, so here's a little mnemonic, I suppose. Formal argument is always rules plus a generalization that helps you sort out the rules and guide them, a formal generalization. So the unit of formal argument, this is the argument of the book, is always more complex than a single atom, like one rule. And of course, that's where coherence seeking kind of is built in right in the nub of legal argument. Same thing, and I'll just be briefer here, with principal policy type argument. To say that we're going to ultimately shape this rule no vehicles in the park by purposes and policies such as no vehicles because it'll serve the end of peace and quiet in the park and the safety of park users. Well, that's fine, but there are, purposes and counter purpose. Safety of park users can require emergency vehicles to come into the park. They're vehicles. So the same need to reconcile, coordinate legal grounds happens at the P level, principal policy level, that happens at the rule level. So anyway, the argument I'm making says, don't think that the unit of decision when law operates decisively is just the last step, the rule applied to a particular result or the particular policy shaping the rule. Prior to that is what's coherent seeking in legal argument. It's shaping the law and the law's grounds so you can get there. So I was right. I predicted that I wouldn't remember the other parts. So can you help me out, Damjan?
Sure. So basically, one of the questions was, how is this, let's say, false distinction from the perspective of American legal realists, that there's actual distinction between, the most important thing we need to study in law or legal theory or in thinking and writing about law is the distinction in positivism and natural law, that this was basically transcended by American legal realism. I think this idea is very strongly present. That is just, I want to ask you if I'm right to claim that. And the second question, which I think you somehow answered, was that I just wanted to, basically this was more a question to clarify to students that your project of reconstruction of liberal practice is a post-realist project, in a sense of you're not going back to the idea of law as logic, but more as, you know, as experience, as an argumentative practice. So basically statements or questions as you wish.
Yeah. Well, I'll do the last one first, and then the natural law one, because I agree with just what you said. It is a matter of the method. It's a philosophical method, but the one that's being used in my book is a post-realist method, and it is a method that focuses on experience, legal experience, and for sure. I mean, I love those terms, and that is the experience of working with the law. Essentially, that's the key thing. And it's and you're in your mind and mine is Oliver Wendell Holmes Jr., who says in the first sentence of first paragraph of his book on the common law, the life of the law has not been logic, it has been experience. And so the date of that book is 1881. But he was a major influence on the realists that flourished in the 1930s. And so, yes, that's a slogan that works to define what the legal realist project is and how it shaped jurisprudence. And I mentioned one, that this wonderful writer, H.L.A. Hart, declares his debt to legal realism quite explicitly. Well, another writer I want to mention is a British writer, John Finnis, is similar. So here's my comment on your other question. Pre-realism, for a long time, there was a classical debate between natural law and positive law, naturalism and positivism. When it shaped up as the claim that, well, to find out what the law is, you have to hearken to the natural law, which is a form of true morality, which is knowable by moral reason. And that's truly law. And it goes back to Thomas Aquinas. There are lots of classical writers. And then the comeback, Jeremy Bentham, natural law is nonsense on stilts. A positivist who says, no. Look at the laws that exist, that are posited, laid down, that's positivism. As a social fact in the world. And that's law. And I guess the point I want to make is that after legal realism and the switch of focus to legal argument, that old debate kind of changes. It becomes a debate about how big a role does moral conception play in legal argument, and how big a role, on the other hand, is the mere facticity of law, just the fact that law got laid down a certain way. And anyway, my evidence for this, I'll drop another name. Oh, I already did, didn't I? Bentham. And I will. Is John Finnis, who's the author of Natural Law and Natural Right, and other works, major contemporary exponent of natural law. I'll just say it this way. But if you look closely at the kind of argument legal argument that Finnis says exists and that he's exploring, it's basically the same as H.L.A. Hart. That is to say, modern naturalists focus on the nature of legal argument. Modern positivists do too. And actually there's quite a convergence in the post-realist world. So anyway, that kind of line through history is very important. I have one last observation, a legal history or intellectual history of law observation. When Max Weber wrote his great work, Economy and Society, that was pre-realist in the American, legal realist sense. But there was a movement in continental, specifically German legal thought, called the Freirechtsschule, the free law school. And the free law school, which Weber knew about and wrote about, is like legal realism. It's a similar view of openness of law, of the codes, and how legal argument will turn to practical moral aims. And so anyway, I'm prepared to make the argument that common law, civil law, the whole thing is post-realist today. All these cultures are. When we just take realism in a broad sense, is the kind of internal critique that the actual American legal realists engaged in, that Holmes engaged in, that the free law school engaged in. So in doing legal theory, there's a line across the page.
Right, great. Thank you so much. Thank you. Just one more question that I'll ask, and then I'll open the floor to students as well. And so basically, I forgot the page where you argue that, but it's not even so important. You mentioned that liberal legality should avoid arbitrariness, right? So it's a
yes.
Counterpoint or something else from arbitrariness. But
Yes.
How do you draw a line between arbitrariness and discretion of a judge? Let's say now in a post-Brexit context, right? Post-Brexit context. So many lawyers, the media in the United Kingdom have been complaining that the European Court of Justice is going too far in its reasoning. So they would say the European Court of Justice is being arbitrary, right? They would say it is, for example, I mean, now I could, let's say the principle of supremacy or direct effect, which actually enabled EU law to be above national laws. It's from the 60s. But let's say that kind of an argument, which was really fundamental in the development of the European Union, could be seen either within the bounds of liberal legality that you're describing, but it could be described as arbitrary by some who see it as going outside of these bounds that you are claiming in this book. How would you answer this charge that the ECJ or any other court is actually judging arbitrarily?
Okay, well, terrific question. Let me see if I can have it included in maybe a little bit of a long-winded answer. A reference to juries, because I don't want that to slide by. That question is on the table. So in the book, I make the following points: that the aspiration to liberal legality, to having the laws rule, is it's an aspiration to have rational development of the law lead to judgment. And the fear is arbitrariness, where you have judgment not under law at all, but judgment that can't be justified as rationally under the governing laws. And the book says, makes a distinction that I like, I think this is a helpful one, between two kinds of arbitrariness that liberal legality is worried about. And I give them names that are maybe a little highfalutin, but okay, here they are. Nomothetic arbitrariness and anomic arbitrariness. Here's the idea. One is a high level of arbitrariness, the other is a low level of arbitrariness. The worry is a high level of arbitrariness. You have some judge, say, court, that just declares that such and such is the law around here in my court. But it's not a statement grounded in the extant laws plus the reasoning methods that are commonly accepted in developing the laws. It's the nicest way to put it is it's a legal mistake, and the worst way to put it is it's just a fiat that happens. Nomothetic, because those terms in Greek, nomos, law, thetic, lay down, lawmaking arbitrariness. declaring a rule that's not there in the statute, not there in the treaty, not there in the common law, well understood. And the liberal legality fears that, of course. Because if you do that, legal entitlement's gone, right? It's not under the standing laws. Okay. The other kind is anomic arbitrariness. And well, I use the term partly from the idea of anomie from the sociologist Durkheim, but it's without a norm, low level, concrete judgment that's just kind of intuitive and not law governed. That's the worry about the jury, that the jury can end up engaging in anomic arbitrariness, just responding to this case, never mind what the rules are. And the worst thing there would be just sympathetic to somebody and forget legal merits. And you don't get to collect your debt against somebody because the jury likes that somebody. And that's arbitrariness, anomic arbitrariness, which again, of course, liberal legality fears and wants to avoid. And anyway, the idea of having a form of argument in courts and two courts governed by the rule of law ideal is that it's a two-sided thing. The rule of law ideal aspires affirmatively to do some things, entitlement, justice, and rationality. And it fears other things and says, stay clear of these other things. And fundamentally, that's a stay clear of arbitrariness and of the high-level lawmaking kind or the low-level applying standards to particular cases kind. Now, the EU example would be, I mean, we're certainly familiar with legal dispute among lawyers and judges, majorities and dissent, where a party to the legal dispute says, here's the law, it has such and such a proposition in it, it's firmly established in the statute, well understood. And then the comeback is, that's not true at all. That proposition is not proposition of the law. We should recognize it would be an invention. It would be our noethetic arbitrariness to affirm it. And you might say that's normal legal argument. We're familiar with that kind of thing. Ronald Dworkin, by the way, I don't know if this is clear, but to me, the best single piece of writing on jurisprudence is his essay called Hard Cases. I just think it's a wonderful thing. I don't fully agree with it, but so what? It teaches. But in it, he makes the point that you could try for rational resolution and keep trying, even though you're fully aware that perfectly knowledgeable lawyers disagree. Legal disagreement happens. Just the fact that there are majorities and dissents doesn't mean there's no law around here. And Dworkin sort of says, because look what they're debating. They're debating what the law is. And an example I often give is that this is true in lots of fields, like in history. We can debate the question. We can debate it because the evidence is sort of spotty. Whether Napoleon, who died in exile, St. Helena, whether he was murdered or not. And there's an argument he was, and there's an argument he wasn't. And people historians disagree who studied it, but they surely all agree there's the truth of the matter. And anyway, Dworkin says the fact of legal disagreement doesn't mean there's no such thing as a right legal answer. And certainly as a matter of analytic philosophy, that's got to be right.
Right.
I don't know if I did justice to your EU question, but that was
I think you did. I think you absolutely did. Also with two levels of arbitrariness, I think you absolutely did. And I think, this gives students also an insight as to how to think about disagreement and how to argue it. So now what I will do is there are a couple of questions. There's a line already. So, I mean, I have tons more questions, but I really will open up now the floor because it's the student session, not mine.
Sure.
So I think Batuhan has a question, and then I will take it one by one.
Thank you, Damian, and thank you, Professor, for your
Hi.
amazing speech.
Sure.
Right. Actually, in your book, you argue that law is developed by judges in courts, and they are the center of legal activity. Some academics would argue that this view of law is too court-centered and outdated, and that we should focus on other institutions of society where law is developed, such as civil society organizations, multinational corporations, etc. And I'm wondering how you would respond to such critics.
Yeah, that's a terrific question. And I guess I would say, first of all, there's so many different legal studies that are perfectly legit, legal history and all sorts of other ones. Then what I'm thinking of is jurisprudence. So surely all these studies are relevant. But your question has an edge point. How come have a study that's so court oriented, that's so focused on the courts? And I guess I come back to what's become a bit of a mantra for me, and that is the idea of law as argument. Law set in motion as argument. That's what the book is talking about. And that's the realist conception of law. It may look wonderful in some code. It may look great in some industry agreement. It may look wonderful in some administrative bodies, regs, when you lay it all out. How does it work? How does it work? And the reason law as argument matters is that the rule of law matters, because it's in argument coming to judgment. That's where the rubber hits the road in the rule of law, right? It's if the law is going to govern, we're under laws, not men in the old 18th century phrase, or older than that, non sub homine. Then the question is, can the law lead to judgment and control judgment or not? And so you have to look at the courts of judgment. You have to look at whoever the judges are. It's perfectly fine to look at administrative deciders and other. We should have a Catholic idea of a judge. But what the drama of the rule of law centers on is somebody in society has the power of coercion over other people in the society, the power to impose coercive legal judgment. And how's the law operating then? I'm happy to include police in that inquiry because at least in the first instance, police are using the law to be coercive. But the rule of law conception says it's all to be raised and reviewed in courts. So anyway, the legal realist switch from just law in the books to law in motion, that's a famous expression by Jerome Frank, a realist of the 30s, and later, who was a judge, by the way, for years in New York, is law in the books is one thing. Law in motion, let's look at that. How does it work? It can be beautiful on the books. Maybe it's contradictory in motion. Maybe it's discretionary in motion. So anyway, that's the rationale for doing jurisprudence from the standpoint of coming to judgment.
Great, thank you so much. So I will now call on those who've asked already questions. I've got a queue. So please just tell your first name and, either if you're a PhD student or whatever, just introduce yourself very briefly. I think BC, you are next.
Good evening, sir.
Hi.
Many thanks for that presentation, Professor. We are very grateful for that clarity and elucidation on legality and pluralism. My question is this: I've read about 2 chapters of the book, but in the process of during your delivery, you made mention of canons of canons of good argument.
Mm-hmm.
Well, I'm trying to go back to my little bit of jurisprudence in my undergraduate days. We were taught canons of interpretation, canons of legal interpretation. I want to know the difference, whether there is any difference or similarity whatsoever in canons of good argument and how it relates, particularly when we are talking about law in motion, whether it has anything to do whatsoever with canons of interpretation and canons of good argument. Because my understanding is law, rules, these are what the lawyers and the judges both dwell on to give a determination. I would like to know whether there's any difference between canons of interpretation and canons of good argument.
Okay, super question. I should have been more careful to distinguish what I was getting at. But here goes. The canons of interpretation that one learns and thinks about, and there are these wonderful Latin maxims that can describe mentioning one thing excludes another thing, in pari materia, all sorts of potential guidelines to interpreting, especially statutes or codes, is not what I mean by canons of good argument. By canons of good argument, I mean criteria that are much more highly general than the guidelines, I'll call them, for interpreting statutes or particular parts of the law. So here's what I have in mind. The fundamental canon, in my terms, but I'm going to switch to criterion, for the fundamental criterion for good ideal argument, practical moral argument in law is that the ideal invoked fits and justifies the rule of law. So the canon or criterion of fit and justification, that's really big. That's like foundational criterion of ideal legal argument, of practical moral argument in law. And we've all of us sort of assumed that when I spoke of free-floating moral argument, or just moral argument you conduct outside law. That's where you're not controlled by this guideline that says, in law, you have to point to principles and policies that are rooted in the laws, embodied in the laws, and those are ones that fit and justify. But fit and justify is so much more highly general than the particular canons of statutory interpretation, like read statutes on the same subject together, in pari materia. That's a much lower level of generality. So that's kind of what I was getting at, these very highly general ones. In other legal systems, you know, the fundamental criterion of a good argument or of coming to judgment might be something as highly general as let's turn to the elders of the tribe, or to the priesthood. Good legal judgment is that comes from a qualified priest. There were lots and lots of theocratic and other non-liberal, that's not to say they're bad, they're just not liberal forms of legality. So I'm talking about very fundamental guidelines or ground rules for legal argument when I use the expression canon. So thank you. It can certainly rightly be used in another way too.
I think this is a great question, BC, also for all of us writers, right? What is the canon of arguments that you use in your dissertation? I think this is really, really valid, and it is connected to a lot, I personally think, to what Professor Sargentich is saying in his book. So we are moving on with questions, I think Khan and then Julia and Nicola. So Khan first.
Hello, I'm Khan Kutul. My doctoral thesis is not on jurisprudence, it's on comparative public law, but thank you, Professor, for your wonderful speech. I just have a brief question about how you would consider Scandinavian legal realism in comparison to American realism, because we talked about the motion of the law and what is law. And I've taken notes here, for instance, in one article by Ross, which I believe was written as a response to H.L.A. Hart that you mentioned quite frequently in your book. So he perceives law as a social phenomenon that relies, solely on the sanction of the man itself. So, and which is basically, which led to future Scandinavian jurists to basically, in my view, obviously, and you may consider it crude, but they basically treated law as the basis of furthering the social welfare state, if you will. So, in their view, basically, the law was moved in one direction and it could not go in another direction. So it is. So I would really like you now. I would really like to hear your take on this, because it is fundamentally different from the realism as it is understood in American jurisprudence. And secondly, this has also impacted Hispanic jurists as well. I believe most of you've heard of it. Manuel Atienza. He's also influenced several Italian jurists as well. So he's also I must admit, he's also quite close to Marxist jurisprudence in terms of considering division of labor and other concepts as interpretative basis on which law would progress. I just would really like to hear your take on those two relatively new movements in law, if you will, compared to American realism. Thank you.
Sure.
Wow, question.
Yeah, sure. Well, on Alf Ross, let me just say why I think those Scandinavian realists like the term and grabbed hold of it. But I don't think it was for the comparison that you made. It's perfectly legit about welfare state. I think that's an additional point. Well, let me try it. So I'll try this. I think that Alf Ross saw a great affinity between his understanding of law's logic, law's argument, and the American realists, in that he had in mind that generalities, highly general conceptions in law, were basically reducible to rules, to down-to-earth rules. He has this wonderful article called Tutu, where he basically says that. And so the idea that highly general concepts in law, that's not the sort of thing we should be conjuring with in legal argument, that they're quite manipulable, and we should get down to brass tacks. This is all Ross' outlook. Brass tacks are rules that we can state pretty sharply, that exist in law and in life, but that he identified with legal realism. It's a perfectly okay identification, though it's not the part I was emphasizing. A major American legal realist is theorist called Felix Cohen. There's a famous article called Transcendental Nonsense and the Functional Approach. And transcendental nonsense are very highly general concepts. And so anyway, there's a lot of anti-concept mongering in the realist tradition. So in that way, I think Ross identifies himself correctly. I mean, I think there is a push in realism to be skeptical about highly general concepts. And that, by the way, is of the sort that you find in the German Civil Code, frankly. And so that is a reason the name works. The idea of seeing laws having a social aspiration, dimension, is a welcome and interesting conception. And I stay away, you might say, with a fairly bare bones idea of aspiration. which is the rule of law aspiration, which can be supplemented in a variety of ways. But in order to be general, I guess, in order to be general. And when you speak of Marxist theory of law, then a figure like Pashukanis actually kind of fits in the quest to be nomological. So I meant a general aspiration that can carry into what's sometimes what's called Soviet legality as well.
Yeah. Thank you. Just may I add something? Apologies to all
Very
my
briefly,
colleagues.
because we have 10 more minutes, so very briefly.
Very briefly, that's I believe more Stuchka than Pashukanis. Pashukanis is more, yeah, and you're perfectly right. But Atienza is more of a social democrat, and he basically, he basically understands. He tries to understand at least constitutionalism as a concept, as a dynamic concept that should be understood not according to just simply legal relationships, subjective law, etc., but also according to the development of social questions such as the division of labor. So he is close to Marxists such as Pashukanis and Stuchka in that regard, but he is more of a social democrat, more in the lines of Bernie Sanders. But thank you very much, and well, thank you very much for your answer. I don't know if we have the time to further this debate, but I'll shut up now. Thank you.
Okay, no, it's fun. It's fun. Thank you.
That's great, Khan. So I think we should make Alf Ross's work on Tutu. It's phenomenal. It's funny. It is interesting. I think we should make it obligatory reading for our PhD students, but we'll talk with Julia about that later on. Just guys, so when you're thinking about writing a PhD, the point is avoid speaking in terms of concepts that can mean different things, in different contexts. Be concrete. See how law in action works. This is all the message of American legal realism. And argue well. Law is an argumentative practice. It is not logic. It is, well-reasoned, argued practice, so to say. So I'm just, just a little bit of a reminding our PhD students what they have to be careful of in their writing. So Julia, I think you're next with a question.
Hi, Damjan. I actually would leave. I would give priority to Nicola because our students should come first. But thank you very much for coming, Professor. And if we have still time after Nicola, then I'll ask the question. Otherwise, it doesn't really matter. Okay.
Thank you. Okay. Thank you.
Do we go with Nicola first? Okay, Nicola, yes, please go ahead.
Hello, Professor. Thank you for your speech. So, based on your book, could you restate how you understand the notion of the good judge, and what, in your opinion, it's not actually a good judge; it's the opposite.
Okay, so the idea just of a judge in general?
I think she judge in general now. So what is a good judge? What is not a good judge? That's an interesting question. I don't know. Yeah, did you hear it or understand it?
Yeah. My thing crackled a little bit when you said my machine here didn't quite get it. So just what is an idea of good judging and an idea of bad judging? Pretty much that?
Yeah.
Okay, so then, and actually, since we have a little time here, I want to take in a little bit the jury question, just if I can. The nomological, law-like legality idea prescribes that the judge is somebody who, the ideal conception of a judge is somebody who operates just under law, somebody who's not arbitrary, and all of whose motives for decisions are laws. And so, that's like personifying the idea of legal entitlement, not under men, but under God and the laws, as Bracton said. But anyway, the ideal conception of a judge, according to liberal legality, is one who just voices and applies legal entitlements, and confers legal justice. So it has that quality of aiming at lining up cases alike. You know, the familiar statuary of blind justice that's the image of the perfect judge who doesn't see all this stuff, but only through the categories of the law itself. Doesn't see the detail of that's legally irrelevant and how nice you are and all that, but just the law. So that's the concept of the judge that works with this rule of law conception. There are plenty of other concepts. I'm trying to sort of say that, although I haven't gone too far into the other ones. There's a very old and persistent idea of judging, that a judge is a person of great intuition and has a feel for things. And that has traces in modern contemporary jurisprudence. And of course, there's the idea of a prophetic judge. Max Weber has the idea of a charismatic judge. A charismatic authority is, in a nutshell, it is written, but I say, I have insight, I have special insight. So charismatic judge is not the same thing as a nomological judge. And so anyway, the concept of the judge that I have in mind is aspirational. It's the idea of having a society where we're governed by the laws, and where we do blind ourselves and as much as we can to extraneous matters. Now, let me just say, so Nicole, that's my shot at your question. Let me just say a word about the jury. I mentioned Weber in that context. The jury for Max Weber is a problem because the jury seems to him to be kind of odd in a nomological, law-like, law-governed system of judgment. He thought of the jury as maybe having a couple of different aspects. Maybe it was a little vessel of popular justice. Popular justice is different. It sort of submits matters to lay people for their practical moral judgments, what it amounts to. And so the jury then would kind of like be a disruptive element in a nomological legal system. And maybe would even have some sort of charisma that it could come up with. Our conception of the jury is fundamentally that it's wholly bound by the general laws as it gets instructed by the judge. But what about the case where the laws themselves aren't fully worked out as rules, as formally realizable rules? And there's tons of, the American usage is very helpful here, standards, not rules. Standards, not rules, means legal prescription, frontline legal prescription, reasonable care in accident law, unjust enrichment in restitution, the best interest of the child in family law, where best interest of the child and unjust enrichment are practical moral ideas. And the jury is asked to judge, to decide according to those ideas. So I think that this is a problem, an aspect of a problem for nomological legality. H.L.A. Hart uses the expression, he uses the rule versus standard distinction. And he says the standard is just a case where the jury is given discretion within law-like limits to come to essentially a practical moral judgment applying concept to the facts. And anyway, so I just wanted to make those observations. The fact is our system is truly dual. It's not just a formally bound system. It does have ideal conception, I think, co-equally built into it. And high-level ideal argument, that's what Dworkin is talking about. High-level, Hercules thinking about how to organize contract law as a whole. Or what is the fundamental objective that could give rise to a woman's right to choose an abortion? The idea of dignity. Dworkin says, forget this transcendental nonsense business. General ideas in morals matter. In laws, morals matter. The low-level version of that is that there are moral conceptions that it's right to summon the jury to decide because they have to do with tactile, concrete, situational, contextual matters, and like what's reasonable care in an accident situation, and that's a trouble for a formal law advocate, but not so much trouble for somebody who recognizes the pervasive role of ideal argument in law.
Great.
So,
great. Thank you so much. We'll go a couple of minutes over time, if you don't mind, Professor Sargentich.
No, I'm at your disposal.
Okay, so just a couple of minutes.
I finished my classes. I'm a free man. I finished my classes yesterday.
Oh, did you? Good for you.
Yes. Yeah.
Good for you. We still have a week to go. So good. So Nicola, if you're, just thank you so much, Professor Sargentich, for this answer. Nicola, or anyone else, if you're considering becoming a judge ever, let me just tell you that American judges see Dworkin as their hero. They might actually start seeing Professor Sargentich as their hero after this book, I have to tell you, because he really explains how I think a judge should actually reason and think. So those of you who are interested in becoming judges, read definitely parts on Dworkin in Professor Sargentich's book. So, it's really about seeking coherence based on policies, principles, and Professor Sargentich actually builds on that, to sort of seeking coherence in formal law as well. Okay, Julia, you had a question.
Yes, if I may. It's quite a long question, actually. So many thanks for coming, and I enjoyed reading most of your book. Thank you, Professor. And while reading it, I was wondering, so my question is twofold. First of all, what's the role? So I agree with you that I'm in agreement with you with respect to the role played by courts and legal practices when it comes to law like law. So yes, if we want to achieve that, this should be the way. But courts and judges and all practitioners, they do not actually act in isolation. So the first part of my question relates to the fact that we actually should consider the power, so the kind of relationship with power, and also the other branches of any sort of government, because law is actually made not only by civil society. I was struck that nobody mentioned parliaments and the governments, and this might be influenced and have different sort of rationale behind, which somehow might influence and impact as well the reasoning and the arguments within a court. And this is the first part, and somehow related to the first part, something that I know goes definitely beyond the scope of investigation of your book, but this is what I am passionate about, what I do for a living. So I teach international law, international criminal law. I'm about to publish a book about the US and the crime of aggression. So of course, my question relates when I think about coherence and the international law, at the international law level, and the US practice and the US approach towards international institutions, and in particular international courts, I was wondering whether you would define, so considering that the US usually somehow try and avoid to have any sort of international courts having jurisdiction over their nationals, if this might hinder you from defining this any sort of so if this would defeat actually the liberal legality as you define it in your book at the international level, and if this might have any impact on the liberal legality mechanism and system you described within the US. So if the external approach towards international law somehow impact and might weaken also this liberal legality within the US, and if so, if you can leave us with some optimism at all, and if you might want to recommend any sort of solution. So when formalization and idealization fail, what can we do?
Well, that's a big one, but you know, in a way, Julie, I think the two parts of your question go together. I'll take them in order as best I can grasp them in flow here. The first one had to do with sources of laws, and in a civic society, let's say a domestic society, and so it's the legislature, the parliament, and then it's all kinds of other sources. Obviously, customs work to a degree, and then there are all sorts of rulemaking agencies in the modern regulatory state. So here are all these sources of norms that are laws, and how does liberal legality look at that? And by the way, the assumption here is that the products of all these agencies and centers of lawmaking are enforced by some tribunal, and that tribunal in the nation state is the kind of court that we're talking about in the drama of liberal legality. So, you know, just go back to H.L.A. Hart for a second. The Hart's legal philosophy imagines that legal argument starts with something called a rule of recognition, and the rule of recognition is accepted by these judges, and the rule of recognition points you to the sources of the laws, and then given the sources of the laws and use them in argument. For Hart, they're regarded as rules, but sometimes have penumbras, and they always have some penumbra. But anyway, so I mean to fully acknowledge that the legal argument of the court-centered kind only gets going if it has itself an understanding of the sources of the rules and laws that it's going to employ. And I didn't emphasize it, but I do mean incorporate all of that. Okay, so but now you sort of say, well, I'm kind of describing a domestic legal system with this claim to monopoly of power over a territory, that old idea of sovereignty. And so what does the conception or picture of liberal legal argument or nomological legal argument have to say about international or just transnational, well, international lawmaking or sources of law in general? I guess this is a kind of a feeble answer, but it's part of an answer. I would sort of say that the world that I believe you're imagining, the world that includes North America, includes South America, includes Europe, and includes parts of East Asia and parts of South Asia, which does, generally speaking, aspire to the rule of law idea, degenerately in some parts of the world, but does aspire, would regard international institutions sort of the same way, that laws should be knowable to common reason. There ought to be criteria that are graspable. We shouldn't have a situation of however the laws are made. By the way, the idea of nomothetic arbitrariness is a good one because this liberal conception assumes that somebody's got it. Parliament's got it. Parliament can make laws. And it's arbitrary in the sense of, with reference to existing laws, because they're new. So somebody has the source of lawmaking, and it can be a national parliament or an international agency. But I guess what I'm struggling to just spit out is that the rule of law conception is not specifically a national idea. It's the idea that there ought to be such qualities of law likeness for laws of any sort, provided they have some coercive edge in the lives of people. And if they do have a coercive edge in the lives of people, then they ought to ultimately honor entitlement and justice. That's the idea.
Right.
I don't know if that was adequate, but that's a shot.
Julia, do you want to follow up? Or, yeah?
Yes, thank you.
Yeah.
It's just that sometimes, you know, this might go on forever for me, but I mean, the thing is international criminal law, starting with Nuremberg and Tokyo, and later on, somehow US politicians and lawyers are very proud of being, you know, the ones that developed it, the ideas, taking some from natural law, some from positive law, but the idea that you can actually judge Nazis and all the other people for the commission of international crimes, it's very much due to the American pressure in London during the war, and then with the Nuremberg and so on. So this is the main and common criticism actually at the UN, at the international level. So if you are the promoter of this idea of the, you know, even putting the Nazis before a tribunal, not to execute them as the British would suggest, you know, but have a trial for them. What happened next? So can it be still what about the coherence of the system, the general application of the law, the principle of equality? If then when it comes to you, then there's plenty of exception not to judge your own nationals, you know, before international courts and tribunals. Yes. Very, very recently with the last administration also to actually criticize the permanent court because they are investigating US soldiers and alleged war crimes in Afghanistan. So how this can, I mean, is it a failure of the very idea of liberalism that the US brought about over decades, or this is part of the, you know, arguments and counter arguments that you were describing? So is there a solution within the system, or it's a systematic failure, let's say, of what the US conceived and somehow exported as an idea?
Yes, yes, yes. So there's hypocrisy galore here. So I would say this is a terrific question. It's a terrific line of reflection. What I was trying to say, and I'll just sort of put it differently now, is that though the rule of law conception can be institutionalized in domestic courts, and that's kind of what I've been mainly talking about. It remains a powerful, extremely general ideal aim. And so its use critically to criticize reality that offends it is part of its use as an aim, just as it is for any other ideal that or practical moral idea that figures in law. And ideals seek perfected embodiment. Ideals seek their embodiment. So the ideal of the rule of law is highly critical of what the US is doing in this regard. Highly critical of the notion of having some enclave where we don't heed the protections of it, and some very fundamental ones about just obeying laws and sticking to laws. So the book doesn't investigate that, as you know. It doesn't go into that. But it does try to say that there's this extremely highly general conception that works in civil code countries, it works in common law countries. It works, frankly, it actually works whenever there's coercion that's possible under in the name of the laws, in the name of the standing laws. This ideal comes into play. And here are these international norms, which after all, many of them are rock bottom norms of behavior. So surely this ideal exists. But like any ideal, the question is whether it's institutionalized or not. And that's the battle, isn't it? I mean, to have an institutionalization of this ideal. Now, I would say that, and maybe this was implicit in what you were saying, that to say this ideal as if it's unchanging by context. I don't mean that. I think that in the international context, it can be developed and spelled out in a variety of ways. But the notion that there's just a line on the globe where international criminal law doesn't reach is plainly an offense to this ideal conception of the rule of law, seems to me.
Great, thank you so much. Now we really have to wrap up. I think we've gone 15 minutes over time. Thank you so much, Professor Sargentich. Maybe one last thought I would ask you, because students very often think of law as really a site of logic, right? But it's a site of argument, a site of fear, aspiration that you also mention in your book. So law is about, you know, it's about struggle. Could you say something, just a very quick thought? And writing a PhD, right? It's all about fear, aspiration, struggle, argument. So could you just say one final thought maybe on this to our students?
Yeah, okay, Damjan, that's Professor Kukovec, that's a good question. And it, the origin of all this for me has been to sort of try to state what is, I think, going on in the minds, basically, but also beings of people who want to be lawful, who want to be, and who want to have a law-formed society. And I'm led quickly to the slogan that we agreed on a minute ago, that the word logic is okay, but it's fleshless. It's pallid compared to the questing character of having a law-formed world, having a law-like relations with your fellow humans, and that it turns out that regarding law as an enterprise, as an activity that's trying to get somewhere and fears pitfalls, it just seems to me much better captures what the legal enterprise, what the legal project is. And I mean, I can't even get away from saying project and enterprise. It's not a staid kind of calm, just purely calm mode of thought, like working out a crossword puzzle. It's trying, it's striving. And anyway, if there's one lesson of legal realism, I'd say that's it, that law is a form of a quest. And it really goes to the point that it's a sort of a never-ending quest, right? I mean, in the international realm, with having laws that can control our behavior. So anyway, to me, that's at the core of the whole thing. It's viewing law as an activity, as something with an aim, something's trying to do something.
Thank you so much, Professor Sargentich. I mean, I applaud you. Thank you so much.
Hey, well, thank you guys. This was a lot of fun. A lot of fun.
We are so grateful.
Thank you for coming.
We are extremely grateful. We hope to remain in touch.
Absolutely.
And really, it's a huge honor to have you here. I have to tell you, there are a couple of students from Slovenia as well. I'm a visiting professor in Slovenia right now, so I invited some students from there who I'm sure are very happy to listen to you as well. Professor Sargentich has some family roots in Montenegro, correct?
Yeah, oh, yeah, absolutely. Yes. So we're sort of paisan here, you know. Yes, my grandfather came to the U.S. Age 16, would you believe it? And from Montenegro, that area. And in family stories, it was a tough life. When I visited, it's glorious, it's gorgeous, and the coast of the Adriatic there. But anyway, so the Sargentiches have been here for a couple of generations, but yes.
Right. So I would just like to thank you really from the bottom of my heart for you to take the time to speak to us on this really, truly amazing book, which will for sure become a canon of legal thought today. And really, thank you so much, and we will be in touch.
Okay, thanks, guys. I'll say goodbye. Bye-bye.
Goodbye. Thank you.
Bye.
So thank you, everyone. This concludes our PhD seminar. Thank you also from everyone, across the world, wherever you are. We hope that you learned a lot from our really fabulous guest, and we'll see each other soon. If you have any follow-up questions, if anything was unclear, if you'd like to discuss more, Khan, I'm sure you would like to discuss more. You had wonderful questions. There's just not enough time to address everything here, but be in touch, and I'll be happy to, and Julia as well, to address your questions. So all of their best from me.
I will now tweet about this event if you're fine. So I took a screen